Hello, good evening, everyone. This is Darren again. Hello, Miss Kachin. 好久不见. Yeah, it's been a week so fast, man. Yeah, so good evening, everyone. For those who are tuning in, tonight is the once a week session with me. I'm, of course, Darren. And for those of you who do not know me, I, yeah, oh, so I speak on the topic of legacy planning and I teach for Finity Academy. So for those of you who are streaming in right now, I gathered that there's a group of you who are waiting to come in. So maybe what I'll do is that I'll just start to introduce myself to the rest of you who are already in the room. All right. So yes, this is my profile. I'm a trainer and I train on the topic of legacy planning for different subject matters. There's also a subject matter that I teach that's on business owners. So my background is actually in financial advisory, and I started to do what I love, which is 15 years ago in the legacy planning. And from there, I specialized a lot in it, and I began to emerge with academic competency, and finally became a TEP, a trust estate practitioner from this STEP board in UK. It's a non-profit organization. So you can see all the different academic qualifications I have. And I'm a very frequent speaker on the seminar circuit, and I speak a lot. So of course, that also means that for those of you who have caught me in my TikTok channels or my IG or my Facebook channel, you will know what I normally speak about. Okay? Yep. So yes, this is a topic I'm mostly doing right now. It's trust planning because there's a big market in Singapore of clients who are unsure how to plan further. They have already done their wills, their LPA, but they always wonder if they have done it well. Have they done it properly? So that's the thing about some of them now at that stage of their lives. Their assets have grown a lot more, and yet they are no longer very sure that the will is the best instrument to hold their assets and convey their last wishes. So, in that sense, I speak on this topic called trust planning because I believe it's a very good solution for most of the customers' problem today. So, if you're a financial advisor rep in this chat group tonight, in this live stream tonight, then you will know that actually many of our clients' wealth have also increased over the years, and they too are wondering where do they go from here onwards. Is the will really enough? And that's where financial advisors, I always encourage you to be better trained, well trained in this area of legacy planning topic, because your clients are aging, their assets are growing, and the conversation will naturally come one day. The conversation they will ask you is, hey, Jeanette, hey, Darren, do you think I've planned correctly? Or do you have any other advice? So when that day comes, I hope you can give them some solid advice, and it can only come about because you invest time in your own education. Okay? Now, of course, for those of you who have missed the earlier part of my introduction, this is where you can find my profile. Like what I say, I belong to STEP UK. It's a non-profit organization incorporated in UK, where people like us who are trust practitioners, introducers, and very much interested in this topic of trust planning goes very deep in, and we belong to this organization. So if you can see the word TEP, that I block it up, it's just to tell you that I am just very qualified in it. Well, it's imagine an advisor and they take on a CFA. So this is the equivalent of CFA, but in the legacy planning world. So full membership to this organization simply means that we are internationally recognized as experts in our field with proven qualifications and experience. Okay. Now, of course, STEP is a global body, global professional body, which means that when I handle cases which are cross-border, I cannot do this on my own. I have to rely on professionals in other countries. So I make friends around the world, where it's important for me to then have in-depth knowledge of the community and let the experts in their own homeland do the advisory, especially when it comes to taxation. All right. Yeah. And these are my practice areas. And growing very quickly is the area called the cross-border estates. And a lot of people keep asking about how to ensure their legacy planning is not contentious. Okay, so these are the keywords today that's happening around the world, no matter whichever part of the world you are. So I'm going to go to my topic tonight properly. So my topic tonight is on when equal distribution destroys family harmony. When equal distribution destroys family harmony. Now, of course, you will be shocked when I say this. Most of your clients think this way as well. They like to do what? Give their properties or company shares equally. So because they are so used to being fair, or rather being equal, that's why they want to do things equally. Like properties, they want to divide equally. Company shares, they also want to divide equally. But however, in all my talks, I always ask them to think twice because you have no idea on the consequences that your equal division might arise. Okay, so that is the current trend today where I advise clients not to really divide properties equally because there are many other ways to divide stuff. You don't have to divide properties equally. Company shares as well. So I'm going to go to perhaps what I call the first few case study. So maybe the first one I want to bring up to your attention is this article published on 2025 April 13, which is last year. What does the heading says? The heading talks about when a $2 million house has too many owners. So just now my earlier picture was a one house divided by two, right? Now this house divided by how many parts? 4 parts. 4 parts means what? 4 parts means that there are 4 equal owners. So this is an article that you can find in Straits Time, and I'll just go through the facts. It all started when the patriarch of the family passes away and divides everything that he's left behind equally among what I call the 2 children. So these 2 children owns in equal share until when they start to die and when each of them will their shares differently, and that's when problem starts. Okay, so the daughters of one of the original owners end up with a 35% share, while the brother has 25%. 2 of their aunts ended up with the rest, with one owning 10%, the other 30%. So can you see right now that there's already a very confusing situation of ownership on a property? But it all started with what? It all started with 50-50. So after the original owners die and distributed via their wills, owner A in blue, owner B in orange owns 50-50. So what happens is that on the right side, you can see the final round of ownership after both owners died and willed their assets away independently. So you can tell now there are 4 colors instead of the original blue and orange. So how does it work? Take a look at how I've drawn and connected the dots. So you can see straight away that the orange color goes to the one in blue and the one in orange. Okay. Sorry, the one in blue and blue. Yeah. So the blue one goes to the green and the orange. So you can see that after one round where both the original owners died, their shares are now divided among 4 parts. And some more is 4 unequal parts. So the dispute was ignited when one of the aunts, the aunts means the aunties, said they wanted to sell the house and distribute the proceeds according to their shares. Because why? They have a stake inside, but they have no chance to enjoy their stake because their nephew and niece are still staying in the property. So in the end, after many numerous rounds of discussion and it broke down, as usual, one of the aunts went to the High Court to apply for an order forcing the other owners to sell. Now, you and me both know, once the court case has been initiated, the relationship is definitely cracked. The relationship is definitely cracked and it's difficult to heal back again. So as legacy planners, I often tell my students, let's think of the best way that our clients probate legacy plans can be arranged in a way that's seamless and trouble-free. Because when there's a need to go to the court to ask for a direction, you end up not only having a direction, but you end up having a severing of the relationship. So as you can tell, up to now, the story is such that one of the aunts has went to the High Court to apply for a court order, forcing the other owners to sell. Now, the High Court judge, Chua Li Ming, granted application and made two important observations that all owners should know so that they can avoid being caught in similar dispute. Well, first of all, Justice Chua found that it warranted a clean break and ordered the sale because the aunts were of advanced age and entitled to cash out and spend the proceeds bequeathed to them by their late siblings. It was neither right nor just to allow the younger co-owners to continue enjoying the house when they will be able to buy their own homes with their share of the sale proceeds. Now, of course, you can imagine if you have already been having a landed house to stay, and then now you are asked to move away because your aunts wants their share, it could be very difficult for them to just uproot and go. Well, it could be, of course, their own personal intentions to use the house for the longest time, but their aunts have a stake in this house and they have no way to enjoy these proceeds. So based on this, Justice Chua Li-Ming ordered the breakup of the sale of the house. And Justice Chua granted the application, saying two important observations. One, the court will only intervene in deserving cases only. So that means in other cases, if it's not of any merit, the courts will just ignore the case and not intervene. In this case, he felt he has to intervene simply because two of the co-owners are aging and they needed the money for their own retirement. And then the two younger ones cannot just simply squat in the house. Okay? Cannot just simply squat in the house, right? Second thing, co-owners will not be forced to buy over properties. Maybe the younger generation owners of the house asked to buy over the aunt's share, but maybe may not have offered a right price. So in the end, when you have four parties who are family members in a buy and sell relationship, you don't have a very good outcome. You don't have a very good outcome because the people who are selling always wants the highest price. The people who are buying always want to buy at the lowest price. So how can you imagine that there will be a very peaceful settlement when the people who are selling just want the highest price? So imagine that to be the case, so they finally go to the court. This is another story about inheriting equal shares, and then later on the fight starts. This was an article in the year 2024. Now, in that time, it was about a father who left behind two shop houses in Jurong worth about 5 million. And what did he do? How did he decree his will? He said that it had to be distributed equally among his three daughters and a son. So now you realize, oh, another case of four people now sharing a property. Actually, in this case, there was peace for the first 10 years. Because why? There were two older daughters who volunteered to look after the estate of the father and manage the rental income from the shop houses. So when I see the word manage means that it became quite fair lah. Although each of them have 25% stake, but nobody said anything. The two older siblings just be fair, collect the rental, and then give out the equal share. All was well for about 10 years until splits began to emerge. And the siblings broke into two fractions. Of all, they became two fractions. So it's Bang Pai A, Bang Pai B, right? With the younger sister siding with the older sister, Olama, and the brother aligned with the second sister. So now it begins to be each of them holding a quarter stake in the property. So no one had the upper hand. Any vote will result in a two-way deadlock. Well, this is a classical case about where everyone is already in one side and yet it's a 50-50 situation. So the two factions could not see eye to eye because both sides insisted on doing things their own way. For example, even when they all agreed to sell the shop houses, they fought over how it should be done. Well, they had no idea how to resolve all these situations among themselves, so they went all the way to the High Court. In the High Court, the judge 𝐂𝐨𝐬𝐬𝐬 broke the toxic impasse by ordering the combatants to appoint a lawyer to conduct the valuation and sale of the properties. That's it. he decided that, okay, you all cannot get along well, it's better to sell. And since all of you cannot agree on the valuation, I'll appoint a third party independently to conduct the valuation and the sale to ensure a process that will be free from the disputes that plague the parties. Now, of course, at the end, he talked about this statement. While this requires the parties to come together to appoint a solicitor, I trust that they will see the bigger picture pertaining to the importance of selling the properties, hoping that both sides will try their best to resolve these issues without coming back to court. Okay, so this is how, in the end, when the parent thought by being equal is the best way out, gave four of the children equal stake. Equal really sometimes don't have the best outcome of peacefulness. Okay, so of course, you can say that why can't they just share equally? I will tell you that at the point of inheritance, each of the four different beneficiaries, or in other cases, one beneficiary, they may have a different financial interest. When you have a very different financial interest at the point of inheritance, then all these that are dividing equally the properties, deed, and titles will result in a very entangled distribution. This entangled distribution is what exactly gets people into a fix. They're glued to each other and they cannot exit because they have a common asset and they cannot agree on how the common asset can be divided. So for parents with many kids and they all want to be equal with each other, there are many ways to be equal, but to force four people to share a title deed of a property is starting to look like not the best idea. Okay? Yeah. So from here, where do we go? I want to share with you about some other case studies which I did not feature or any newspaper article was found. But these are stories or these are cases that could even happen to you. Now, this is about business, and a father who manages the family-run property or hardware business left the business to four kids in equal 25%. Yet, out of the four children, only one had worked in the business for over 20 years, while the three of the other kids, although owning shares, have decided to have external career. So in the end, you have four people who owns a share, but only one person active. This active person who's in the business wants to reinvest the profits for growth. Of course, because this is his career, right? But the other three passive siblings wants to liquidate the assets for immediate cash. So now, what kind of outcome will we have? Definitely, it will be what? A deadlock. Okay, a deadlock. So, of course, three of the kids wants to force the remaining one to sell the business. But if he doesn't want to sell, the business can't be sold. So this is where we call this a deadlock in the business. And end up like the other previous cases, the siblings have to go to court to force for a partition and sale of the property. Okay. Lesson in this case is what? This is called a deadlock trap, okay? Equal shares, zero progress. The legacy lesson here is that equal ownership without a governance structure, like a family charter or shareholders agreement, turns a legacy into a legal battleground. That's why in recent years, I pay a lot of attention to how business people leave their inheritance when they passes away. Because if it was not done well, the business could be lost overnight in just the next generation. Okay, so this is where we share with the answers or share a solution with the clients. Don't just give equal ownership without a family charter, which means how things should be done. Okay, or a shareholders agreement. If this is not a family business, but between two shareholders, they should also have a shareholders agreement so that when one party dies, everything is according to the rule book or the shareholders agreement. Okay, for those of you, I notice you are PMing me. Can you please type in the chat group the questions so that we can actually have some interaction as well? Okay. This is the other kind of situation that's happening in Singapore, where again, the parent leaves share of a family investment whole co equally to two children. You know, parents always want to be equal, right? So child A has been a primary caregiver for the elderly parents and the manager of all the parents' assets, while child B, well, has freedom and lived abroad for a decade. In this situation, when you have two children but only one stays behind to take care of you, how do you feel about the other child and how do you feel towards this caregiver child? For the caregiver child, this person might also have sacrificed his or her own career simply to become the primary caregiver for the elderly parents. And it is definitely not easy because so much opportunities have been sacrificed in order to be the caregiving role. And this is always sometimes that nobody talks about the pain and the sacrifices that caregivers have to put up with or have sacrificed. Now, the conflict is that internally, the children may have different feelings. The child A might feel that, hey, I took care of my parents for such a long time. I'm the only one that has ever been around for them. I should get a bigger share. So this is called the expectation of this child A. Okay? While child B, I have nothing to quarrel with you. I have 50% share, so I just want my 50%. If you are taking care of our folks for the longest time, it's because you are there, you are in the country, but I'm not, I'm overseas. How do I take care? So this could be each other's standpoint, and then they all feel that they are all correct. But to the poor parent, how do you feel when you look at your two children arguing about how and where they stand in this position? So if you still continue as a parent, leaving shares equally to two children, but yet two different children has been contributing to you differently, being one more active and one more the other passive, then you know the resentment will boil over. The caregiver sibling will feel exploited. And then, some relationships, actually, the cracks are formed after the parents die, especially when they look at the will and hear that, eh, Appa give you 70%, I only have 30%. Okay, 算了, never mind. Since Appa love you more, give you more money, you do more work, lor. So these are the kind of things that we are now starting to be told by clients. Okay. So I always tell clients it is very difficult because two kids you have, not all of them give you the equal attention as well. So what do you do? So I will also suggest to them fairness is and equality and fairness are two different things. Okay. While you want to be equal as a parent, you must also account for contribution. And that's only being fair. And contributions are in two forms, financial and non-financial. In my course that I teach, I gave the financial advisors a solution. Because after every time they tell me about the cases in our class, I will always have a solution so that in the end we preserve the most important thing to all family members or to all parents, harmony among your children. So whatever solutions you give must have that outcome in mind, which is harmony among the children after the parents pass over. Now, this is the in-law influence and the glass house. Okay. Now, father, mother passes away. In the end, the estate is divided equally among three children. Equally among three children means what? Means that there are three children, but they share one title deed for the house. There is only one car, but I don't know how they're going to share one car. Maybe they also share one car. Okay. But yes, Miss 𝐿𝐶𝐻, the best is only to have one child. Well, there are so as long actually it doesn't matter if you're one child or three children. It's about how in the end you plan. But I agree that if there's one child, there's also nothing to think about. The parents just give everything equally. Okay. So in Singapore, the conflicts are about inheritance and how does inherited assets be treated if there's a divorce? So you must understand in Singapore, there's something called a matrimonial asset. And the definition is that the inherited assets are generally not included into the matrimonial pool of assets when people divorce. But many people have changed this inheritance asset into a joint asset to be shared with the existing spouse. When you do that, you have changed the character of this asset. And this asset now becomes what you call a matrimonial asset. Usually it's because the other spouse who did not inherit, but because of the spouse inheriting it, helps to make it a much better version of the gift. Like the house is substantially improved. So finally, when you have this situation happening, If a sibling moves their family into the inherited property, that means to say that each of us has 1/3. My 1/3 that I have, I also bring my spouse into the home to share with my siblings. And then if we ever divorce, my 1/3 share, which becomes a matrimonial asset by the court of Singapore, may be actually resulting in a forced sale. Because why? The other half wants the money or the half share of my 1/3. So sometimes the weird part is that the other two siblings find themselves partners in a property with their former brother-in-law or sister-in-law. Okay, so this is called the in-law influence. Okay, and of course, the legacy learning in this case is that equal division often ignores the external risk each child carries. Today, if you are with your two other siblings sharing a house equally, which means each of you have 1/3 each. What if one of your siblings is bankrupt? You know, the court may jolly well force the sale of this property so that this 1/3 is given to the official assignee, while the other two siblings just get the cash. And if they actually were staying inside, then this would have been a lost house already. Okay, so when your partners or your joint inheritors goes through a matrimonial asset division or goes through a form of financial difficulty like bankruptcy, these are what we call the external risk each child carries. A trust will have ring-fenced the asset, which means if this was left to me, I would have told the parents, you have 3 children. Please don't give the property equally to them. You have no idea how your each child will turn out in the future. So you can consider to use a trust vehicle to inherit all your assets and then is independently managed away from the children. So what you can do in the end is that the trustee can just divide the stream of income from this property, which is in a trust, to your 3 children equally and fairly. Okay? Now, this is the shocker. The widow leaves her estate in an equal shares to her son and a nephew. Wow, these are some of the things that why drama is all about. Just when you thought you're the only son and your mom will leave everything to you, suddenly, besides you, your cousin, which is a nephew to your mom, is also included in the will. The family is shocked. Why the nephew? Well, what the son didn't know was that the nephew was secretly tasked with caring for the widow's mentally challenged brother. And hence, the equal split didn't make sense on the surface to the son, since the son didn't even know about this arrangement that the cousin has with the mother. The son will naturally challenge the will, because you will say things like, I believe my cousin has influenced my mom in a very bad manner. That's why my mom has left a share of it to him or to her or to him. Okay. So this is where it's a problem. All right. Yeah. Legacy lesson learned. An unequal split. Okay. An equal split, but ignoring the specific needs or hidden responsibilities invites challenges. That's why it's always important to have a transparency in what you do. And the letter of wishes are often some of the best way to explain the why behind the what. When a person dies, and if all that is left behind is only the will, and the will is usually very technically, structurally clear, but does not carry the rationale of how things are done. For example, in this will, it could be I so and so leave this house to my nephew and to my son in equal share. But you didn't explain why you want to give to the nephew. And your son is having no other better idea except to imagine the worst, that there is an elder abuse or there's an elderly influence. Okay. So Ms. Kachin asks, if the estate is under the trust, one of the siblings went bankrupt, other siblings' beneficiaries' share will be protected? Yes, because the property is not owned legally entitled it by the 4 children or the 3 children. It's owned by the trust. And the trustee is serving the beneficiaries because the beneficiaries are ultimately the beneficial owners. So if one of the siblings has a problem, like in what Ms. Kachin asked, went bankrupt, then the other 3 or the other 2 are not affected because they still can receive the stream of income from this property trust management. Okay, so I hope I answered your question. So finally, if equal division is not a good idea, so what should you do? So what should you as a financial advisor then advise your client? That is the one thing your clients are looking at you for direction, for advice, for counsel. This is the moment of truth. If you can give good advice, you will be closer to the client in terms of your value. Since the client has learned to look beyond you as a financial advisor, but even towards you as the legacy planner. Okay, so what should you do as a financial advisor? Anyone can tell me? If your clients come to you, do you know what to dispense as advice to them? If you do not, then I encourage you to start picking up skill set that will give you an edge over others, but more importantly, the competence to showcase to your client that you have the experience and the competency to do more work for them. Okay, so I teach in my legacy planning classes, leaving a lasting legacy, how the solutions can be like. For example, if these were the cases that I covered in my class, then I would have given the students or whoever that gave me the scenarios they're in, one of these three as a solution. For example, the family charter, which is to set the rules of the family before the patriarch or the matriarch leaves. This is like a handbook of SOP, setting inside there imprinted the family culture. This is how we do things in this family. This is called a family charter. Like for example, some families have this habit of gathering together every Friday night to eat dinner. This is one of the rules or stipulated conditions in a family charter because the family charter simply says how we do things, culture. Some of the solutions will include insurance as an equalizer, and this is the biggest advantage if you know how to talk about this solutioning. Well, while you can give a business to the active child, you can give an equivalent cash payout to the passive child. So that each of them have their own ownership and don't have to be entangled into owning the business. And finally, letter of wishes to explain your will, to explain the conditions inside your will, to explain the conditions inside your trust. The letter of wishes can be the last piece of your words with the heart and the rationale to explain why things are done in the will or the trust. So this is important. And these are some of the solutions that I teach in my Leaving a Lasting Legacy class. Okay? So at the end of it, as financial advisors, you have a very big job because your clients are always caught in this moral dilemma. Do I want to be equal or do I want to be fair? And sometimes fairness and equal are not on the same part and hold the same weight. If it's left to me, I will always choose fairness as more important. And even more important is the family harmony. So there are many solutions you can do to help create a better relationship for the client's children after they departed the world. Okay, so that's where one of the important outcomes could be like. And then I will teach you strategies on how you can get the clients to be fair during the lifetime. Because there's one more solution I didn't put there. It's called lifetime gifting. All right. So tonight it has been fun. I've managed to share some of this case study. I hope you benefited. For the audience in my group, thank you very much. Some of you I've never seen before, but if you are around, say hi so I can have a chance to interact with you. And this is the time, if you have questions, please ask. Well, while you are still consolidating your questions, then of course I want to tell you about this course I'm doing. You may have heard of this reference to this course in the last half an hour. Yes, I run this course. It's called Leaving a Lasting Legacy. And the legacy we're talking about is not only about assets, it's about also the values, the relationship, because legacy is not just about assets. So for those of you who are interested as financial advisors to learn more, this could be the moment you can scan this QR code, or you can refer back to Kyra, who, if you are past students of Finity, go ahead, refer back to Kyra so that Kyra can help place you in one of the courses that I'm running. Okay? Yeah. And of course, like I said, if you come via my TikTok or my Facebook or my live, then of course you can approach me as well. No matter how, the endpoint is the same. We want you to be more competent in what you do with your clients. And with that, I'm going to end the night by saying thank you very much. And I've reached the end of tonight's session. So I see that there's no one there asking question. Does it mean that everyone is very clear about what has been discussed? And does it mean that all of you are interested to come attend my class? Okay, yeah. So if there's no more questions, I will call an end to tonight. It has been lovely spending time to discuss all this case study and to share the importance to you, because all this case study could also be the materials you have to go and showcase to your clients that sometimes a simple will may not be enough. And most times, doing things fairly could be more important than equally. All right, I think that's it. So
Yeah.
have a lovely night rest. Then
Thank you, Darren. Thank you so
yes.
much. Thank you. Thank you. Yeah, thank you, Darren, for generously contributing your time and expertise to the Finity live stream. So we really have all the audience supported us for the last 1 hour. Thank you to all the learners who have tuned in. So those who have already following us for the last few episodes, please do not miss for the next 2 weeks, because Darren, we would be inviting him again to speak on legacy planning. So next Thursday and another last Thursday of the month, he will be sharing with us with more shocking news on legacy planning. Yeah, so thank you, Darren, and thank you all the participants today. Yeah, so before we end the live stream, maybe you can just help me to say thanks to Darren again, and have a wonderful evening ahead. Yeah.
Yeah, wonderful evening ahead. Okay, everyone. Good night, rest.